court does look to any advanced guardianship designations. Again, for most developmentally disabled adults who didn't have the opportunity to suggest who they wanted to be guardian, it won't apply. But this is the exact same process when mom is in the nursing home and now needs a guardian. This is the exact same process the family has to go through. And mom may have designated somebody to be her guardian if one were needed. So, but those advanced guardianship designations are only suggestions.
I don't know if you've got a later part on the slide, but also if you as parents make a designation in a will, for example, of who you want to be guardian of your disabled adult, and I use that incorrect term, but if you nominate somebody, that is something that we would consider. If you are the parent and you've been the parent and something happens to you, but you put in there, I want Mark to be the guardian of my daughter, that is something that's considered by the court.
Right, and that was actually a change made when the probate code was revised a few years ago. Because before you could only nominate guardians for your minor children, and that requirement was taken out, and now it's for any age child of yours. You can nominate who you want to be the guardian, but again, those nominations are only suggestions. The court is the only entity that can actually select the guardian. I've had situations where people thought they were the guardian because mom and dad left it in their will that they were the guardian. You're not the guardian until you've gone to court and the court has said, you are the guardian. So, and it's not quite how it works, but you're not blessed. You are issued a nice little pretty piece of paper. But that guardianship designation is only a suggestion. Yeah, Judge Wolk needs to determine, is Uncle Harry still that appropriate person? Mom and dad may have nominated Uncle Harry, 20 years ago in their will, and they didn't know Uncle Harry was now a crack addict.
And we
well,
had that.
Judge Wolk will check into that. Say, Uncle Harry, come here, let's have a talk. And if,
The other thing is on the evaluations, just because the doctor says Johnny needs a guardian doesn't mean that I am going to find that Johnny, it is not a medical determination, and this is very, very confusing and challenging to people. The doctor can say, yes, he needs a guardian and or a conservator, and we can, for one reason or another, decide that he doesn't, or vice versa. We have evaluations come in a lot where the evaluator says there is no need, he's high enough functioning, whatever, and we still have the hearing, and I've had court-appointed attorneys who represent the ward come in and say, well, Your Honor, the evaluator said that they don't need it, so have a good day. And I'm like, sit back down. We have some work to do here, because as Mark said, if the circumstances are such that this person may be high functioning in a 30-minute interview and may do okay on a mini mental status exam, and function, autism is a pretty good example of that, but they're going to run into traffic if they're by themselves. They're not going to be able to handle money. They're, those types of situations. There are circumstances where an evaluation may lead to one conclusion and a hearing may lead to another.
Are parents two people?
Parents are, mother and father are two people. Yes.
Absolutely.
Last time I checked, you were two independent people.
You are one, but as far as the law is concerned, you're two. But Judge Wolk's point with that doctor's evaluation, that's just one piece of evidence that the court considers. It's not conclusive, it's not absolute, and I've walked into court very confident because the doctor's evaluation unequivocally stated this person needs a guardian. And then the judge was like, well, I'm just not feeling it. Because the proposed ward was sitting there and presented very well. So we actually had to wind up forcing the treating psychologist to come into court to testify. And that's not easy, especially under HIPAA. Number one, psychologists and psychiatrists, their ethical rules prohibit them from testifying against their patient.
Except under court order.
Except under court order. But, and what we discovered, a court order is not enough. There had to be a finding of that this evidence could not be attained any other way. And that's what almost got us caught up. Because the doctor came and the doctor knew what his legal responsibilities were, and he alleged, there has to be some other way to get this evidence. And guess whose responsibility it is to show that there isn't any other way to get the evidence? the petitioner. So the people who come to court to say they need a guardian. So it can get complicated. And again, when you're looking at your particular situation, go back to that very first slide. What's possible, what's probable, what's inevitable. Yeah, when you're looking at your child, I don't want to scare you from seeking guardianship, because it can get hard. Look at your situation, and these facts might not be your situation.